everyone. My name is Craig Bronsnick, and I am president of the Rutgers Federalist Society. The Federalist Society Executive Board would like to thank you all in advance for coming. We are proud to announce that today's event will feature Mr. Neily, who will speak about judicial engagement. Mr. Neily will present for about 40 minutes, followed by a question and answer session. If you have to, leave the class, please leave the door quietly instead of letting it slam. That'd be great. Now our Vice Dean of Rutgers School of Law, Dean Ronald Chen, will welcome our guests.
Thank you, Mr. Bronsnick. Everyone, welcome, Mr. Neily. It's a great pleasure here at Rutgers to welcome you again to Rutgers Law School and to present what sounds like a very, very scintillating topic. I say that in all sincerity because looking at it, as Mr. Neily and I were talking before, the Institute for Justice and I, when I was the public advocate, had occasion to join forces on a topic that might, at least tangentially, relate to what you're going to talk about now, which is the use of judicial review and the powers of judicial review in some ways to curtail government expansion, expansion of governmental powers. Mr. Neily is a graduate of the University of Texas, both undergraduate and law school, and he clerked after that on the United States District Court for the District of Columbia for Judge Royce Lamberth. After private practice for several years in Dallas, he joined the Institute for Justice and has worked on a number of cases involving economic and property rights. He has been instrumental in creating the Institute's Center for Judicial Engagement, which I gather, whose theme is centered around a lot of what you're going to be talking about today. On other areas, on a personal capacity, he has litigated, he was co-counsel in District of Columbia versus Heller, which I assume some of you at least have studied in some classes, about the interpretation of the Second Amendment of the Constitution. And I gather is a very, very busy public interest litigator. I know about that in the work of the Institute. So I know you'll all join me in welcoming Mr. Neily and looking forward to his remarks.
Thanks for having me up, and thanks for turning out today. I learned not to ask whether you showed up for food, so I won't. So I work for a public interest law firm called the Institute for Justice. We're really the nation's only libertarian public interest law firm. I always hasten to add that's libertarian with a small L, not a kooky capital L. I'm not in the Libertarian Party. I'm really not political. But I am very passionate about what I do. I think probably that will come across momentarily. I love suing the government. I love kicking bureaucrats in the shins. I love kicking bureaucrats when they're down on the ground. And so I thought I'd start off just by explaining a little bit to where I'm coming from, why I do what I do, and then explain what this judicial engagement term is. Really a term that my organization invented a few months ago, and kind of explain what that means and then how it plays out in a couple of specific circumstances. Dean Chen mentioned that I was a law clerk when I got out of law school. I clerked for a judge in D.C. And because of the nature of that work and where it is, I would say most of the cases involve the government in one capacity or another, either prosecuting somebody or sometimes involved in civil litigation, other kinds of cases. And I came away from that experience very profoundly affected because basically I never in my entire life saw anything as dishonorable and unaccountable as the government and the way it treats citizens in court. Let me say that again. I never saw in my entire life anything as dishonorable and unaccountable as the way the government treated people in court. And I don't believe that the government lawyers that were in court were dishonorable people. To the contrary. I think they were simply they were advocating basically zealously, which we're all supposed to do, within the bounds that were provided to them by the courts. And the courts have essentially provided the government, in my view, with so much leeway and have so stacked the deck against citizens that the way citizens are treated in court, again, in my view, is extraordinarily dishonorable. The government's attitude in any given case seems, no matter how bad somebody's life has been screwed up, the government's attitude seems to be, your life is fine, it's not screwed up. If it is screwed up, it wasn't us that did it. If it was us that did it, we had a good reason that we can't think of right now. Oh, also, you can't be in court because you don't have standing. And I saw this over and over again. And by the time I got done with that year-long clerkship, I basically realized that whatever there was out there available that was as opposite as what I saw in court in terms of the way the government behaved, I wanted to be that. I wanted to represent people in these kinds of cases when they were trying to stand up for their rights against the government. Because in my view, again, the deck is just extraordinarily stacked against people who are trying to assert their rights. And I actually, believe it or not, had no idea just how bad it was until I started actually litigating as a public interest lawyer, which I started doing in the spring of 2000. Because the other thing I realized was, to me, just how systemic all of this is. I think you have to sort of take it with a grain of salt. I've been a libertarian public interest lawyer for 12 years. It doesn't make me right, but I do have a certain perspective, a certain perception. I just don't believe that government officials, by and large, are motivated by a genuine desire to do good, to advance public policy. I think it happens sometimes, but I don't think that is the general guiding impetus of most government officials. I think their guiding impetus is to get reelected, frankly. And if they're a bureaucrat, to expand the power, the budget that they have and the scope of their power. And basically the way you do that is you essentially loot one group of people to give their stuff to some other group of people that you think might vote for you. And that's, to me, mostly what politicians do. That's mostly what guides state legislatures, is, to me at least, is essentially kind of figuring out how they can hand special benefits to groups of people in order to get reelected. There's actually a whole, and this isn't just me, there's a whole body of economic theory called public choice theory. It's actually won a couple of Nobel Prizes that gets into this in a lot more theoretical detail. Again, that doesn't mean that it's right, but to me it really maps very closely into what I've seen as a public interest lawyer, and I'll get into that and give you some examples so that we can sort of think through it. Some of them are actually kind of funny, so hopefully this will be an entertaining talk as well as hopefully informative. What do we mean by judicial engagement? Well, it's interesting because to explain what the term judicial engagement means, you have to actually understand that much of what passes for judging in constitutional law these days can really be, I think, fairly described as judicial abdication. Essentially, yeah, that may be bad, that seems really unfair, and you should totally take that up with the legislature that did that to you. Or you should totally take that up with the agency that's sticking it to you that way. That's the attitude, unfortunately, that many judges have. And I'm not blaming them personally. I mean, frankly, the Supreme Court, in many cases, requires them to have that approach, that essentially, look, I'm not really here to vindicate your constitutional rights. If I can come up with any reason why the government might be doing what it's doing, I have to rubber stamp it. So judicial engagement is essentially the opposite of this. Judicial engagement is the idea that in any case involving somebody's constitutional rights, judges should be engaged in the case to the point where they consider only facts. They don't make up facts, for example, on behalf of the government, which is something they routinely do. We'll get to that in a moment. And they should be basically asking themselves, is the government plausibly pursuing a genuine public purpose here, or is it really doing what I described earlier, which is essentially just taking stuff from one group of people and giving it to somebody else in order to essentially promote their own political interests, or for some other reason. Sometimes it's just naked corruption. That happens too. But the other term the other reason we invented this term, judicial engagement, is to not only as a counterpoint to judicial abdication, which is I think what judges are engaged in a lot of times, but also as a counterpoint to this idea of judicial activism, which I'm sure you've all heard. In fact, it's kind of a drumbeat. Really, in my view, a totally overblown concern. My organization, the Center for Judicial Engagement, which is an organization within the Institute for Justice, actually is releasing a report on Wednesday, in which we sat down and we decided, you know what, let's just look and see exactly how often courts strike down laws, specifically the Supreme Court. How often is the Supreme Court really striking down laws? I mean, is it a bunch? Is it true? Some of you may have heard Arlen Specter, as he was leaving the Senate last year, direct quote from Arlen Specter, said that the Supreme Court is eating Congress's lunch with judicial application. The implication being Congress is, just completely bound, can barely do anything because of the Supreme Court's judicial activism striking down all these laws. Does anybody want to take a guess how often the Supreme Court strikes down laws? What percentage of the time does it? Well, let me ask you this first. Does anybody know the historical free throw average? Is going to sound like a weird comparison. I hope I get there. Anybody know what the historical free throw average is in the NBA? It's about 75%. Anybody know how often a Major League Baseball pitcher throws a strike? About 62% of the time. I actually looked this up. How often do you suppose a congressman gets it right when they legislate? In other words, they get the ball in the constitutional strike zone. Because unless they're perfect, right, we assume they're going to enact some unconstitutional legislation. And a judiciary that's doing its job properly should have a strike down rate greater than 0. We can agree on that? What do you suppose it is? Anybody want to take a wild guess? We looked at it going back 50 years. Supreme Court strike down rate of federal law?
0.05%.
It's 0.5%. And it's actually 0.05% if you include state laws and federal regulations. So I don't know how you get that. We didn't include it.
No.
Anyway, it's an infinitesimal amount, is the point. And basically, unless you think that Congress is getting it right more than 99.5% of the time, it is certain that the Supreme Court is underperforming, not overperforming, not judicial activism. In fact, my view is that they almost certainly are allowing tons and tons of unconstitutional laws to get past them. And the idea that striking down a mere 0.5% of all federal laws passed amounts to judicial activism, I think, is nuts. But that's where I come from. Let's take a concrete example that I've not actually litigated. I don't even know if this has been litigated, but I think it helps to really focus the question. What's your name?
My name's Craig.
Craig, where do you live?
I live here in Newark.
All right. Have you had constitutional law yet?
I have.
All right, good. I'll ask you a question. What would you say about the constitutionality of a law that got passed that said that you personally may not leave your house without permission from, you live in Newark, right? Without the mayor of Newark. Permission from the mayor of Newark. Constitutional or unconstitutional?
Sounds pretty unconstitutional.
Anybody feel differently about this? I actually, even as a libertarian public interest litigator who's almost foaming at the mouth by this point, I actually think you have to ask why was the law passed. So for example, if you've just been exposed to the Ebola virus and there's good evidence that you're going to kill everybody that you meet and they need to quarantine you, now what do you think?
That could be a compelling interest.
Yeah, I mean, it starts to look more reasonable, right? Now, what if instead the only plausible reason for the law was just that you didn't make a sufficiently large campaign contribution to the mayor's re-election campaign?
Well, I guess in real politics that would also be a compelling interest.
No, be serious now. If you actually went into court, do you think a federal judge would allow them to keep you in your...
Absolutely not.
No, of course not. Of course not. Now, where in the Constitution is your right to travel, or your right to leave your apartment for that matter? Where is that? Does anybody know? Does anybody have one handy? I've got mine right here. It's probably not going to do you any good, but where in the Constitution does it say that you have a right to leave your apartment and travel around? Just on a whim, wherever you want to go, without even asking somebody from the government. Yeah.
Well, two answers. One is it's one of the privileges and immunities in the 14th Amendment. And the other would be that it doesn't need to be in the Constitution because the Constitution says what the government can't do, not what people can do, and we have a God-given right to go wherever we want.
So some very interesting and compelling answers there. Very good. Looks like you've read the Cliff Notes. Yeah, so I mean, if it's the federal government telling you that you can't leave your house, one answer is, well, you just don't have that power. There's nothing in Article 1, Section 8 that gives you the power to dictate when people can leave, and so it's not a power that was conferred to you. Now, it's trickier when you're dealing with a state government, because state governments are generally understood as something called the police power, which is just a residual power to go around doing good. So that argument wouldn't work at the state level, right?
Well, they would still need to balance that with after the 14th Amendment.
Sure.
The Civil War stuff.
Yeah, and I think the state government would need to have two things in order to do this. First of all, there would not have to be, or you'd have to have basically a legitimate justification. At least that's, even the rational basis test says you have to have a legitimate justification. And second, they would have to not impinge on any right that is specifically, or maybe not specifically protected. Right?
Narrowly tailored, if it is.
Maybe or maybe not. We'll get to that in a minute. Maybe narrowly tailored. So the point of this exercise is simply to underscore a very simple point. And I can't even tell you, I mean, this is so fundamental, but this is basically not a part of our constitutional jurisprudence, at least in many cases, the kinds of cases I litigate, which I'm going to give you an example of next. It matters why the law was passed. I mean, doesn't it really matter? You're not going to let the mayor come in and say, well, geez, maybe he went to a zoo when he was a kid and he was near the monkey house, and monkeys sometimes have Ebola, so I don't know if he has Ebola virus. I just think we better not take any chances. You would laugh at that person. I mean, it'd be ridiculous. If you were wearing a judge, you'd probably sanction a lawyer who came in and tried. I hope you would. Please do, by the way, if any of you get to be a judge. But let's take almost a similarly ridiculous example that isn't hypothetical. It was a case I actually litigated. I specialize in occupational liberty. I represent people who are trying to earn a living in the occupation of their choice, and they can't because of some ridiculous licensing law. We represented everybody from African hair braiders in California and Mississippi to, we actually just won a case in Louisiana. We represent some monks who make caskets. If you don't know what a casket is, it's a box. It's a big box. They make wooden caskets, and people love them. They're very simple, but kind of, elegant. And but in Louisiana, it is a crime to sell a casket unless you are a fully licensed funeral director. Interestingly enough, in Louisiana, it is also a crime to sell a floral arrangement unless you are a state licensed florist. Good. I see some eyebrows going up. True story. I actually litigated this case. Anybody want to guess why that law was enacted? Not you. You already know. No, seriously. Does anybody have any idea why that law might have been enacted? Anybody taken economics at all? Remember when I mentioned public choice theory? It's obvious. I mean, it really is obvious. There's only one reason why a law like that gets passed, and it's because a bunch of florists got together and passed it and said, now we're going to be state licensed florists, and to be a state licensed florist, you have to pass a test. Because God forbid you're selling floral arrangements, right, without government authorization. And Louisiana, I mean, they're so brazen sometimes that you almost have to respect them. They actually didn't just say that you have to pass a test in order to sell floral arrangements. They then said, and in fact, the test is going to be a 4-hour practical exam where you have to do 4 floral arrangements, and guess who's going to grade them and decide if you're good enough to be a state licensed florist? Other state licensed florists. And it was ridiculous. I mean, it was so subjective. I remember it's been a few years, but some of the questions that the judges would rate you on are whether your floral arrangement had the proper focal point, whether your flowers were picked properly. I mean, this is just insane. It's insane if you think that this law might have been passed to advance a genuine public purpose, but it is perfectly rational. If you ask yourself the very question that I suggested that you ask as of this law, about this law that says you can't leave your house without government permission. In other words, if you stop acting like a child and join the adult world and ask yourself, why is this law on the books? But here's the beautiful thing. If you're a government lawyer, you get a huge handful of free passes from the government, as I mentioned, from the courts, as I mentioned before. Does anybody know? So you do actually, according to the Supreme Court, you do have a right to earn a living in the occupation of your choice, subject only to reasonable government regulation. Does anybody know what constitutional test applies to this right? When you think it's been violated, you have to go into courts to try to vindicate it? Anybody? The lowest standard of review ever invented? Really low? What? I heard it. Yeah, rational basis review. Okay. So rational basis review. 2 things I want you to know about it that are very important. First, rational basis is a classic example of judicial abdication. If you hear a judge ever saying rational basis or see rational basis written in an opinion, that judge has told you, I am on vacation. I am not judging for the purposes of this opinion. And it's also an intellectual fraud. So if anybody ever tries to talk to you seriously about the rational basis test, you will have a leg up on them because they don't realize that they're perpetrating a fraud, and you do. And you can have a really interesting discussion because in my view, no serious person ought to be talking about rational basis review as if it is a real constitutional test. It's not. It would literally be like taking a zoology course and spending half of the semester on unicorns. It would be absurd. It's made up. And yet, it is the standard of review that applies to most of constitutional litigation, because the way the Supreme Court sees the Constitution basically is a giant ocean of government power with little tiny dots of meaningful liberty. Those are little islands of meaningful liberty. When I say meaningful, I mean basically a right that you have a chance of going into court and having some chance of vindicating. Where, for example, the government has to actually be candid and come in and say, well, we passed it for this particular purpose. Here's some evidence that shows that we actually had a problem that needed to be addressed, and we've done a pretty good job of trying to address it. That is what I would call a robust standard of review, something like intermediate scrutiny or strict scrutiny. Rational basis is completely different. It's a complete joke. Rational basis review just says to the government, look, all you have to do is go into court, Make up something that you can say with a straight face. If the judge asks you for evidence, don't worry about it. You don't have to have any. There's case after case that says the government doesn't have to have any. And even if the law really doesn't make any sense because it's just completely, the disproportionate to the supposed problem, that's okay too. It doesn't have to have any proportion. You just have to be able to say it with a straight face. So just for fun, let's put on our government lawyer caps for a moment. I won't hit you if you do. What would you say in defense of a law that says you have to have a license from the government to arrange and sell flowers? Just get real creative. And remember, it doesn't have to be true, it doesn't even have to make sense. It just has to not be insane. Yeah.
Last week, 5 people were killed by poor flower arrangements.
Okay, 5 people, but they weren't.
It's a detail.
It's a detail, right. I mean, it could have been.
Could
Yeah,
have been.
there we
They
go.
could
Now we're on the
scratch,
right
they
track.
could
How
get
could they have been
infected,
killed?
They
How
get
could
scratched
that-
by they didn't take the thorns off, they can get infected, then the
Yes.
infection could
Now,
spread.
there we go.
All
Okay.
these things.
So now we're rolling, we're making stuff up. It doesn't have to have any real connection to the real world. I mean, 80 or 90% of flowers come from Colombia. I've never been there, but I bet they have some really scary poisonous bugs down there. There could be spiders in those flowers, right? And believe it or not, you actually touched on something that they said right off the bat. I actually had a grown man, apparently sane, under oath, I was deposing him at the time, tell me that possibly one reason for licensing florists is to make sure that people don't get injured by corsage pins. Because I don't know exactly, it was hard for him to just join that up, but somehow apparently with unlicensed floristry you could have a real bad corsage pin injury. So the one that really stands out in my mind, it was actually my favorite one that anybody offered was, I don't know how many of you have seen, like the thing the bride, it's a nosegay, it's called a nosegay, I just remember that from the case, a bridal bouquet. The stems are fastened together with something called floral wire. It's a green wire, and they just wrap it around the stems, and I can see some of the women nodding good, okay. And tape, and that's it. And this guy actually told me under oath when I was deposing him that one of the possible reasons for licensing florists is if that's not done properly, that wire could come unspooled at exactly the wrong time, and then the bride could get tripped up in it and fall down the aisle, and that would just be awful. Literally, look at the guy. Are you serious? But then I started thinking to myself, I'm not actually sure that's not a rational I think it's stupid. I think it's crazy. But I'm not sure it's insane. And that's the rational basis test. And believe it or not, you can actually look this up. Fortunately, so we lost in the district court. But Hurricane Katrina came along and displaced all of my clients. So when we were up on appeal, the case was actually mooted, believe it or not, on appeal. And one of the beautiful things, at least in the Fifth Circuit, is when your case is mooted on appeal, you can actually ask the court to vacate the lower court opinion, which we did and they did. So the district court opinion is no longer good law. But believe it or not, this district court judge actually upheld the law partly on the basis of infected dirt. And he didn't even ask him what it could be infected with. Just took it at face, oh yeah, there could be infected dirt, that sounds bad. And even when we pointed out there's nothing on the licensing exam about infected dirt, so there's not even a connection between this completely fanciful concern with infected dirt and your licensing law, it didn't bother him. And that is judicial abdication. That is the essence of a judge just mailing it in, not really asking what is absolutely the fundamental question of any liberty-infringing law. Why is this really on the books? It's not on the books to prevent people from getting sick from infected dirt or getting pricked by a corsage pin. It's on the books for one reason and one reason only. And honestly, there is no other plausible reason why you license florists other than to protect existing florists from competition. And that really is the difference between judicial engagement on the one hand and judicial abdication on the other. Judicial abdication, at least in this case as reflected in the rational basis standard, is essentially just to put both judicial blinders and earplugs in it, just not to disconnect yourself from the real world. I mentioned a moment before that another case we had was the Louisiana casket restrictions, where you have to be a fully licensed funeral director to sell caskets. We actually won that case in June. 2 of my colleagues took that case to trial and won. And it was a wonderful example of judicial engagement. In fact, if you got really interested in this, you could look up these 2 decisions, the one on Louisiana florists and the one on Louisiana caskets, and just compare and contrast the way the district court judges went about their job. The district court judge who struck down the casket law did exactly what I just suggested, which he looked at the state's explanations, which, by the way, these are pretty funny, too. If anybody want to take a crack at why you should have to be all right, we'll go fast. So I'm not making this up. It's so fun to talk about this because I get to say all the time, I am not making this up. The best they could come up with, the state's explanation for why you have to be a fully licensed funeral director to sell caskets in Louisiana is that people in Louisiana are fatter than people in the rest of the country, and you might sell them a casket that they don't fit into, and that would just be traumatic at the funeral, because it's crazy. But that's the explanation, and of course, again, the real explanation has nothing to do with public policy. It has everything to do with protecting state licensed funeral directors from competition. I actually tried one of these cases in Oklahoma, and one of the things that we proved at the trial was that state licensed funeral directors in Oklahoma, where they are shielded from competition by a similar law, they mark up the prices of their caskets anywhere from 300 to 500%. And we're talking about something that costs anywhere from $2,000 to $5,000. They are absolutely cheating people. And of course, the sad thing is it's people who've just lost a loved one. They're exploiting them and they're cheating them. And they're basically doing it with a government-granted monopoly. And so anyway, the Louisiana Morticians Board has actually appealed that case to the circuit, so it should be interesting. And we've already got a circuit split. My boss won a case in Tennessee. I lost the case in Oklahoma, took that up to the 10th Circuit, where I had a really surreal experience. The 10th Circuit basically said, we'll take that at face value, that this law is solely about advancing the economic interests of state licensed funeral directors, and that's fine. That is a legitimate, favoring one group at the expense of another group is a legitimate state interest. Again, perfect example of judicial application. I would have thought that no one who had had 7th grade civics would possibly think the Constitution would permit that, and yet 2 judges on the 10th Circuit said that it does. The other judge concurred. He didn't want any part of that rationale, but he basically found that it could be a consumer protection measure, which of course it's not. Let's talk about eminent domain for a moment, because I think that's another example where we've seen judicial application, particularly, you may know about the Kelo case, familiar with the Kelo case. So I was one of the lawyers that helped litigate Kelo. One of my colleagues, Scott Bullock, who Dean Chen has worked with, actually argued it. Real quick, the basic facts in Kelo were these. There was a kind of a middle to lower middle class, working class neighborhood in New London, Connecticut. It's called the Fort Trumbull neighborhood. It had either the good fortune or the misfortune, depending on how you look at it, of being located right next to where Pfizer had just built its World Research Facility. And basically what happened is that Pfizer entered into a deal with the powers that be in New London that that essentially they would expand their facility if they could be promised this entire neighborhood scrape clean. Now how do you do that? How do you promise to deliver to a huge company an entire neighborhood scrape clean because maybe some of the people in that neighborhood don't want to sell? Well, you invoke the power of eminent domain. It doesn't matter if they want to sell because you take it. You take it through raw force, which is what the city of New London proposed to do. And also, you just got to love sometimes working on the other side of the case with the government because they almost invariably miss no opportunity to like do things, even when they're doing something really bad like this, they even find a worse way to do it. So Suzette Kelo, who's a good friend of mine I know very well, she was actually handed what amounted to an eviction notice, essentially like, you have to take this money or we're just going to kick you out and bulldoze your house on the day after Thanksgiving. So that was really classy. And anyway, so basically the question in Kelo when it went up to the U.S. Supreme Court is, can you take somebody's house, and in this case, several houses, a bunch of businesses and houses, there are about 8 holdouts by the end of the end of the day when we actually got involved in litigating the case. Can you take somebody's home or business and just give it to a private developer, essentially to make Yuppieville? And that's what they were proposing to do. Pfizer essentially wanted to turn this neighborhood into Yuppieville and take what were, $80,000 or $100,000 townhomes or little cottages like Suzette's. I don't know if you've ever seen the picture. It's this beautiful little pink cottage, and turn them into $600,000 houses for Pfizer executives, and put up a 4-star hotel, which was ludicrous because the neighborhood was never going to support a 4-star hotel. But that was their idea. That was their dream, their vision. And so when I went up to the Supreme Court, the question is, does the public use provision of the Fifth Amendment, nor shall private property be taken for public use without just compensation? So there are 2 limitations there. First, you can't take somebody's private property unless it's for a public use. And second, you have to pay just compensation. We were litigating the first part of that pair. And the question is it a public use to take somebody's home and give it to another private party just because they're going to build something nicer? And it was crystallized during the oral argument when Justice O'Connor asked the lawyer for the city. She said, well, under your rationale, it seems that the government could just take, you know, a Motel 6 and give it to the company to build a Ritz-Carlton just because that's going to be a nicer hotel that will pay, you know, more taxes. Can they do that? And he looked at her for just about a half a second. He said, yes, yes, they can. And you could see Justice O'Connor literally physically move back away from the guy, which was funny because she had actually written the most eminent domain-friendly opinion up until that point in a case called Mitkiv. And she wasn't having any of that. Another funny part of the backstory on this is that we found out afterwards that this lawyer for the city had been through a number of moot courts. You go through tons of moot courts, obviously, when you argue a Supreme Court case. And they had asked him that question, some variation of that question, a bunch of times, and every single time he had said, no, you couldn't do that. And he had some explanation why not. So we found out that only on the morning of the argument that he decided he was going to answer that question differently, and even his client didn't know that his answer had changed. And like when he gave the answer in the Supreme Court, like their entire table like looked at him like, you're crazy. But they still managed to get 5 votes. So Hilo held that you can take somebody's house, give it to another private party, just because you as the government think maybe that new use will generate more money in taxes or jobs. Does anybody know what became of this neighborhood in London? No? Yeah?
Yeah, they didn't go through with the project.
They did not. The project, they managed to bulldoze all the homes. They got that much done.
Right.
So for a period of time, for the last year or two, it was just overgrown with weeds and populated by feral cats and birds. So it was like, oh, by the way, $88 million in taxpayer money was spent on it for nothing. Well, I mean, not nothing. You had a feral cat park, I guess. But and then most recently, they've turned it into a dump, so people can haul their Hurricane Katrina. Irene. Is Irene the latest one? Yeah, Irene. Waste stuff to basically where Suzette's home used to be, and just dump it, and that's what you got. Now that's anecdotal, but it actually turns out we've done a report on this. It actually turns out this happens quite a bit. Basically, when you have local government officials gambling with other people's money, it's not a process that imposes a lot of discipline on the planning, and a lot of them fail. A lot of them fail. A lot of them just end up as a terrible waste of money. But you can imagine why they would do this. I mean, imagine Pfizer comes waltzing in, and they have their property developer, and they've got a PowerPoint presentation, and they're showing you what your riverfront's going to look like if you just bulldoze Suzette Kilo's house, and everything will be great. And maybe once in a while, Baltimore's Inner Harbor was redeveloped through eminent domain, but at the same time, probably some of you have heard of the Poletown case. This is where they essentially just bulldozed an entire ethnic neighborhood in Detroit. It was actually Poletown for Polish people. They bulldozed it so GM could expand its plant, and nothing came of it. It was a waste. So I described Kilo as an example of judicial abdication for the following reason. I think that when the Constitution very obviously means to impose a certain limit on government power, in this case, that you can't take somebody's private property for something other than a public use, that any interpretation of that provision that effectively writes it out of the Constitution is very obviously an example of judicial abdication, because you have substituted your preference for essentially an omnipotent government, at least when it comes to eminent domain, for the clearly contrary provision of the Constitution, which says no, it needs to be for a public use. And the standard that the Supreme Court announced in Kilo is so open-ended that I think it was Justice O'Connor wrote in a footnote to her dissent. She said only somebody with a really stupid staff would not be able to meet the standard, because essentially all the standard required was a plan. I mean, how hard is it to have a plan? I mean, I've got my iPad here. I can come up with a plan in about 5 minutes that would meet the Supreme Court standard for taking somebody's property. And the really sad news is, well, there's good news and bad news. So the bad news is this opened the floodgates. In the years running up to Kilo, we documented about 5,000 properties that were taken through eminent domain abuse, at least as we defined it. Within a year after Kilo came down, we had counted 15,000, so it was off to the races. And there's also been studies to determine whether Justice O'Connor and Justice Thomas, who also wrote a dissent, they both predicted that the effects of the decision would not be evenly distributed throughout society, but that instead a particular group would bear the brunt of eminent domain taking. Does anybody want to guess what that group is?
African Americans?
Yeah, it's dispossessed people. It's people who are at the lower level of the economic stratum. I guarantee you, it doesn't matter, black or white, although it is oftentimes, we represented, for example, there was an African American community in I believe it was West Palm, Florida. They just happened to have some really nice oceanfront property down there that up until that point hadn't been worth very much until, I can never pronounce the guy's name, the Wayne Huizinga, whatever his name is, the blockbuster guy, just decided he was going to expand a yacht marina. And suddenly that property became really valuable. Did they want to pay fair market value for it? No, they did not. So what are they going to do? Take it through eminent domain. But yeah, so, and then the study concludes that in fact, yes, that essentially there's a very strong correlation between being politically non-influential, economically dispossessed, and having your home taken through eminent domain. Particularly if you have either the good fortune or the misfortune to have bought, for example, property in a geographically desirable place that maybe it wasn't that geographically desirable at the time. We actually had a case here in New Jersey, the city of Long Branch, where people had bought houses on the Jersey Shore in the 50s and 60s at a time when, you know, it was far enough away from New York City. It just didn't seem like it was that valuable. But suddenly, 50 years later, it's incredibly valuable. And sure enough, a developer comes to town and says, hey, you know, we make a lot more in property taxes than all these one-story bungalows along the beach. Condos. Well, yeah, of course. But you can imagine what the homeowner's attitude was, like, yeah, no, I think it's a really great location too. I mean, actually, one of our clients had a sign out in front that said, if you wanted this house, you should have bought it in 1965, like my dad did. And that's a real problem, because of course, these people as a group, they don't have the political muscle to stand up, for example, to a well-connected developer. And it's also a very fundamental problem that the framers were acutely aware of, and it shows up in the Federalist Papers, and it's really a large part of the reason for having a constitution, and that's the tyranny of the majority. So you think about it, if you live in Long Branch, chances are you don't own a house on the beach, because of course there's only so much beachfront property. I mean, is it any skin off your nose if those people have their homes bulldozed to build condos that'll maybe bring in more money, maybe improve the schools, maybe buy a new fire engine? No, that sounds pretty good to you. And so if you don't have constitutional limits that can check this impulse, then you really you have this very real possibility for this tyranny of the majority. And unfortunately, this plays out a lot in eminent domain takings. And as Justice Thomas and Justice O'Connor both predicted, the effects of eminent domain abuse are not evenly distributed throughout society. And in fact, they fall hardest on the economically dispossessed and the politically non-influential. And I think that's something close to a crime. All right, let's finish real quick with a subject that's near and dear to my heart. I was one of the lawyers that litigated the Heller gun case. I realize not everybody here is on board with that idea, and that's fine. I'm not really here to convince you that we were right, sort of water under the bridge. But before we do guns, let's take something maybe a little more user-friendly to ease our way into this sometimes controversial subject. Does anybody know there is a widely available consumer product that is much more deadly than guns that most of you probably use on a pretty regular basis? Do you know what this product is? It's the automobile. The automobile creates carnage in this country that far exceeds what guns do. And yet we tolerate them. In fact, we even allow 16-year-olds to operate them while texting. That's scary. But it's true. Cars kill a lot more people than guns do. About 45,000 lives per year. Guns do about 35,000. About half of those are suicides. I don't think that's fair that guns have to take all of the hit for suicides. There's actually pretty good studies out there that show that if you take a gun away from someone who's suicidal, they will find another means. So, you know, something between maybe 10 and 20,000 people are non-suicides are killed by guns every year. I happen to think that a lot of that is attributable to our atrocious drug laws. I think that basically we push a lot of people into a very violent trade by criminalizing drugs. So I also think that maybe it's not fair to put all of that on guns either. I think our incredibly misguided drug laws, that's a topic for another day, of course. But so point being, we tolerate this much more dangerous item, and we allow teenagers to operate it, to own it, to drive it around while texting and talking to their friends, sometimes while even drinking. And no one's talking about banning it. No one's talking about making it a crime for people in the car. Why not? Well, they're so darn useful. They're just really useful. Interesting question, though. Do you have a constitutional right to own a car, do you think? Anybody? It's not in there. I think you do. And here's why. Go back to the 14th Amendment. I'm not like a 100% strict originalist, but I think you have to have some operating theory in the Constitution. And I think that looking back in history and trying to figure out why people enacted a particular provision is a pretty good guide to how to interpret it if there's parts of it that you don't understand. It's not infallible, but I think it's helpful and I think it's relevant. Does anybody know why the 14th Amendment was enacted, ratified, 1868? Big thing that happened a couple years before that, Civil War. Yeah, so we had Civil War, basically, over the question of whether you could own people. The answer was no. The side that was fighting against that principle won, so you can't. We had the 13th Amendment making illegal slavery, thank goodness. But many southern states essentially acted as if that never happened. Their attitude was, screw you, we're going to continue to treat African Americans, newly freed slaves, they called them freedmen, as if they were still in a state of constructive servitude. And they were able to do that because they were the local powers. And of course, I assume most of you know from history how this was enforced, sometimes formally, but sometimes informally through terror, lynchings, and it was one of the, other than the institution of slavery itself, it's probably the ugliest thing that we've ever experienced in this country. So Congress was very unhappy about this, and they determined that they were going to make sure that the federal government, including particularly federal courts, had the power to stop it. And so they passed the 14th Amendment, which protects basically three basic values: equal protection, which sure you're all familiar with, due process, probably also familiar with that. I wonder if anybody in the room has any working knowledge or concept of the privileges or immunities. There's actually the third clause of the 14th Amendment. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. It's a third of the amendment, or at least the operative part of the amendment. Can anybody name any of your privileges or immunities? Anybody? Isn't that amazing? And there's like no disagreement among modern day constitutional scholars that the privileges or immunities clause was probably intended to be the real workhorse of the 14th Amendment. And here you are in law school, some of you have even had law school, and you can't name a single privilege or immunity of the United States. I'll name two for you. I'll name two. One is the ability to travel. How do I know that? Well, the reason I know that is because one of the tactics that the southern states used to try to keep people in a state of constructive servitude is they said, you can't leave your employer's place of business without written permission from your employer. You know what your employer's place of business was? It was a plantation, right? You follow? So you're still stuck on the same plantation where you were a slave, and you're basically making no money. And you can't leave in search of better economic opportunities without permission from who? Your boss, master, right? Yeah, you're damn right you have a right to travel, and it's protected by the 14th Amendment, because without that, without the ability to walk away from people who are treating you like that, freedom is meaningless. You don't have any. The other right that I'm equally convinced is protected by the 14th Amendment is the right to own a gun. Why do I say that? Well, guess what? If you're trying to terrorize and subjugate somebody, what do you have to do? You have to disarm them. There were African Americans who fought in the Union armies, and they came back to the South with guns. And one of the first things that the powers that be in the South did was they passed laws saying you can't own a gun if you're black, and they would also take guns. By the way, there was white people who fought for the Union armies in the South too, and many of them supported equality for blacks. And if they didn't get into the program, they got disarmed too. And when asked to give an example of a privilege or immunity that was going to be protected by the 14th Amendment, one of the most frequently given examples by proponents of the 14th Amendment was the right to own a gun. They had reams of evidence in front of them about the mob violence, the terrorism, the subjugation, everything I've just described, and the disarmament, the systematic disarmament of not only blacks but also whites who supported equality throughout the South. And there's absolutely not a shred of a doubt that they intended to empower the federal courts to protect people's ability to own guns, to defend themselves from Southern tyranny. No doubt whatsoever. So, does that translate into modern times? That's a subject for another time. Let me just sort of take us back to where we ended. It is incredibly important, in my view, that judges ask why laws are really put on the books. So let me give you an example. In Chicago, which my co-counsel Alan Grua just got Chicago's gun ban struck down, they had a law that said that you had to re-register. You were forbidden from owning a handgun, but you could own a shotgun or a rifle. You had to re-register that gun every year. And if you missed, even by a day, your re-registration deadline, you forfeit the gun. They take it away, and you can never own it again. Can you imagine if the same applied to cars? You miss re-registering your car by a day, and they just come and take the car. No compensation, they just take it. At that point, one begins to suspect this is not really about regulating the ownership of this item. It is about discouraging people from owning it in the first place. And that's precisely what Chicago's law was all about. It wasn't to regulate gun ownership, it was to discourage and to forbid it. And that takes us back full circle, as I said, to the example that we had about can you leave your house. Is that law constitutional? I don't know. And you don't know until you ask yourself as an adult, not a child, not somebody who's pimping for the government behind the rational basis veil, but as an adult who really cares and thinks that it matters whether you get constitutional right as an engaged judge. And only then can you really know. So thanks very much for coming. I'll take some questions. I know some of you have to go. If this is interesting, please check out, we have a website. It's ij.org/CJE. Actually, you know what? Just Google Center for Judicial Engagement. Just do that. And we have a whole bunch of stuff on there, including some videos and podcasts. And so if you have to go, fine. I can stick around for another 10, 15 minutes and take questions. But thank you very much. Thank you. Appreciate it.
If you have any questions, please introduce yourself and keep the question in the form of a question and as brief as possible. Thank you.
Yeah.
Mr. Neily, I have a question.
Sure.
Do you think New Jersey's gun laws are constitutional?
Do I think New Jersey's gun laws are constitutional? If I understand them correctly, I think not. Tell me if I'm wrong. Do you know anything about them?
I mean, it's almost impossible to get a carry permit.
Right. That's my understanding.
It's only you argue that are like connected closer to a police officer or a governmental official. That's it. Otherwise,
Right.
they don't do it.
So, okay, so that is my understanding as well. So let me give you that in like 90 seconds. Basically, you have two different kinds of gun laws when it comes to carrying, having a permit to carry the gun. Most states have what is called a shall issue system, that essentially if you meet certain criteria, you don't have a criminal background. My state of Virginia, you have to take a test, for example. But pretty similar actually to what it takes to get a driver's license. If you meet those requirements, they have to give you a carry permit. Other states like New Jersey, Maryland, Massachusetts, New York, California, a couple of others, they have what's called a discretionary permitting system, where, as you basically just described, you have to kind of convince whoever it is, usually it's a local chief of police or a local law enforcement official, that you have a sufficiently good reason. And I don't know a whole lot about New Jersey. I know more about Maryland. For example, hardly anybody in the state of Maryland has been granted a permit. I mean, even, for example, women who have been raped and can prove that either that rapist is still in the neighborhood or that it's, so point being, I think they're unconstitutional because I don't think that any constitutional right that is a serious constitutional right is left up to the unreviewable discretion of local officials, which is what you have here in New Jersey and what you have in these other states. And by the way, also there's some history too, you might not be surprised to find out. These kinds of gun regulations actually go back to the period in the post-Civil War South, where some states realized you can't have a law that says, that white people can own guns and black people can't. So what they did instead was they said, well, you have to ask for permission from the sheriff if you can have a gun. And of course, that would be Sheriff Cracker, right? And you know what he's going to say, if you can even find him. And so I'm not saying that all laws that have that feature today are racist, but certainly many of them have a racist origin. And in normal constitutional litigation, that would be relevant. I don't know whether it will be in this setting. But yeah, I think pretty clearly unconstitutional. Anybody else? Other questions? Yeah.
So, and do you think there should be a utilitarian aspect to this analysis? And I understand that if you do one for Jim Crow South, they'll have a utilitarian argument as well. But even in present day, does that have a place in this Constitution?
Let me ask you what you mean by utilitarian, because it may be, I want to make sure we're on the same page.
Just take your car analogy.
Yeah.
Cars obviously have great utility that offset
Right.
the dangers they have. The argument against guns, well, what's the utility of guns? And I think that's the most common argument for distinguishing the two analogies.
Okay, no, I got you now. I appreciate it. Here's what I would say. Generally speaking, when we decide to take a particular right seriously, we don't open it up to a lot of balancing. In other words, the government, like the First Amendment free speech, like pretty much everybody agrees that we have a right to free speech, right? And usually, when the government tries to regulate speech, in most settings, it is required to come in with some evidence that there really is a problem that needs to be addressed, and that the regulation they've chosen will have a reasonably, is reasonably tailored to advancing whatever interest it is that they've identified. But I wouldn't really describe that as utilitarian. I would just more describe that as sort of pragmatic and say, look, what is the problem that you're concerned with? And then you, as the government, you have to actually identify what it is. And, if it's, for example, this guy used to work for the CIA, and if he gets to publish that book, he's going to name all of the, undercover officers that we have working in the world, they'll all be killed. That's a pretty good reason, And I would say that's not so much utilitarian or balancing. It's just saying, look, do you have a damn good reason for silencing this person? Answer, yes, I do. Have you tailored it pretty well? In other words, have you said, well, it's just this one book you can't publish. You want to write, something about aardvarks, that's fine. Yeah, exactly. So, but the reason I think the question is so interesting is this, is that as you kind of move down the scale in the direction of what the court considers to be less and less serious constitutional rights, or rights that they take less and less seriously, what happens is that two things happen. First, the burden tends to shift from the government to justify the law to the citizen to persuade the government to permit them to exercise the right. In other words, the citizen has to prove that they have a sufficiently strong interest in exercising the right. And the default setting is the government gets to say no. And the other thing that tends to happen is the government bears less and less of an evidentiary burden. From strict scrutiny, where they actually have to come into court with genuine evidence that really will stand up in court, to rational basis review, where they can just make stuff up like infected dirt. And what's going to be interesting, I think, with guns is to see where that shakes out. Because a couple things a lot of people don't realize about this, but it actually turns out that every study that has been done shows that guns have a great deal of utility, much more than you would think. Basically, no credible person I'm aware of disputes that guns are used more often by private individuals to stop or protect themselves from crime than guns are used to commit crimes. I was floored when I read that, by the way. And I would say that pretty much everybody agrees on it. Really, the only question is where between about 100,000 defensive gun uses a year and 2 to 2.5 million defensive gun uses a year is the right number. But there's no dispute among even strongly anti-gun social scientists that guns are used very frequently for legitimate purposes to stop crime and protect people from physical violence. So that's a utility question, I suppose. And then the other side of the coin would be, how efficacious is the law that you have passed? In other words, how narrowly tailored is it to the problem that you say that you are concerned about? And one of the things that is going to be incredibly difficult for the government to overcome is the fact that in every state that I'm aware of where they have made it easier to acquire and to carry a gun violence has dropped, gun accidents have dropped, and in some cases crime has gone down as well. So in other words, the rigorous gun laws appear to be completely inefficacious at promoting any public. They don't make people safer, they don't reduce the number of accidents, they basically just do nothing. Pretty much like I would say our drug prohibition. Absolutely no impact on people's use of drugs. And I think there's every reason to believe that gun prohibitions essentially have the same effect. Criminals have them, and law-abiding people don't. So if you want to call that utility, I suppose that will creep into the analysis eventually one way or the other. But the real question is going to be, does the government have the burden of justifying the restriction, or do you have to justify your desire to exercise the right? That's point one. And point two, how seriously will the courts take the evidentiary burden? In other words, will they just sort of accept anything the government comes into court with, or will they treat it more like they would in a normal case where they say, there's got to be some real sort of legitimate scientific backing behind your claims? And I think that's a very open question. It hasn't shaken out yet. Yeah, Craig.
Well, I certainly have other questions as well, but we could discuss them later. But regarding the utilitarian thing, that argument comes up a lot with regard to Kelo.
Yeah.
They make the economic utilitarian argument that, what do you do when they know there's a private project, when an occupant of a home or an owner of a home knows that, and they're going to hold out, the holdout argument. And basically, what you'd have to do is take into consideration that or would you agree that you would have to take into the consideration that a constitutional right in of itself is a part of the utilitarian argument for a society, that the rights of property, would you go down that path, or is that
I'm not sure I would phrase it that way. I think I see where you're going with this. The question is, for example, maybe the government can make a pretty strong argument that they have to be able to have a broad power of eminent domain, or they won't be able to, to do these kinds of projects. And I think actually the whole point of the government having eminent domain power addresses that. So if you are literally trying to build a highway from here to there, yeah, I get it. Even as a libertarian, I get that you need to have eminent domain power to do that, because you can't build a highway that goes like this around people's private property. Another example, and it's not even eminent domain, I don't know, you guys have probably all had property, right? So you remember the saying in property that when you own a piece of land, it goes all the way down to whatever the Latin is for that far down to, the sky. But then, suddenly you had commercial air travel, and that just wouldn't make any sense. You can't have people running around saying, get that plane out of my yard. It doesn't make any sense. And so property was flexible enough to say, you know what, we're not going to allow people to assert a claim that they can exclude commercial airliners from their air rights. This doesn't make any sense. But at a certain point, what you say is, look, when something is called out in the Constitution as a right, like the right of private property, that seems to, that means that it was something particularly important to the people who wrote the Constitution. And I think, to go back to the earlier point, that the burden should be on the government to demonstrate that that right has to yield, or the government will be unable to advance some incredibly important objective. Take the New London case. We actually brought in one of the leading municipal planning authorities in the entire country who testified, oh, you could totally do this project without Suzette's house. You could do that. Every one of those properties could be left in. You can build right around them. You can integrate them in. If you're really concerned about what they call the leopard effect, that some houses will look different than others, you can throw them a few bucks to put a new coat of paint on the house, or you can change their awning a little bit. It'll work fine. Because it had this basically unfettered power of eminent domain, the city of New London had no incentive whatsoever to listen to this guy. They just completely blew him off. They didn't want to hear about it. They promised Pfizer they were going to give them a completely scraped clean neighborhood, and that's what they intended to deliver. I think the holdout problem, by the way, is really overdone. If you don't know what the holdout problem is, essentially when the government is trying to acquire an entire area of land, like Fort Trumbull neighborhood in New London, what happens is basically once people realize what's going on, you get holdouts who essentially say, oh, you need this entire piece of property and you've got all the lots except mine. Well, you know what, the price just went up by $1 million. And that does happen, by the way, it does happen. I'm not here to tell you that it doesn't. But basically there's a couple ways of dealing with that. One way that has been very effective is basically using, having secret acquisition. You basically have an agent go out and acquire this property in secret using different, and by the way, private buyers do this all the time. When somebody's trying to buy land to build a football stadium or something like that, they don't want the word to get out that the Dallas Cowboys are about to be located in your neighborhood, of course. So anyway, that's one way to deal with it. Another way to deal with it, as I said before, is to build around them. I mean, it actually warms my heart when I see projects that go forward, and I've read about a number of them, where somebody holds out, and man, they're just trying to play the lottery, and then they just hold out a little bit too long, and the person who's building that hotel or that condo development says, screw it. You know what? Fine. You stay. We'll make a little alleyway so you can get to your crappy little house, and we're going to build this beautiful hotel line. You can see these pictures. You can go online and see pictures like that. And that's the way it should work out. Because guess what? Now that whatever the value of that property was, it just went to zero. No one's going to pay for that. And you played the lottery too long and you lost. That's how it should work out. Now, if the government really, really needs to do something, you have to have that army base right there. You have to have that highway. Yeah, I get it, all right? But all I'm saying is make the government prove it.
Did you say secret buying agents? Was
Yeah.
that? Yeah. That was,
Yeah. So anyway, so I think the basic point here is that when you essentially tell the government that it doesn't need to worry about people's rights, that it doesn't need to worry about their property or their desire to speak or to own a gun or whatever, it basically doesn't care about those things, and it treats them as if they are insignificant. The government takes its lead from the courts. I absolutely believe that the government takes its lead from the courts in terms of how important these kinds of rights should be. And I'm not saying any of this should be set in stone. I'm fairly pragmatic when it comes to these things. All I'm saying is I think in most cases it makes sense to put the burden on the government to show that there's a real problem here that can only be addressed in this way that they're addressing it. And they've actually made some effort to tailor the law to their stated concerns. That, by the way, is judicial engagement. If that sounds good, I really hope one of you ends up as a judge one day and I find myself in front of you, because I at least won't throw anything at you, I hope. But anyway, thanks again for being here. I really appreciate it. Hope you had a good time. Thanks.